Members, good afternoon. It's the appointed time. We have a quorum. I call to order the meeting of the Bills Committee on Tobacco Control Legislation Amendment Bill 2025. This is our sixth meeting. Item 1 on the agenda, meeting with the administration. Will our Secretariat invite the government officials to join us? Thank you. Now, since the officials are here, whenever you are ready, Mr. Deputy Secretary, Mr. Eddie Lee. Now, follow-up items from the last meeting. The Secretariat has issued the following meetings. List of follow-up actions arising from the discussion at the meeting on the 24th of June this year. That's CB bracket 31044/2025 bracket 01, and also the administration's response to the issue raised at the last meeting. That's LC paper number CB bracket 31044/2025 bracket 02. So maybe we can first invite the Deputy Secretary and his team to briefly walk us through the reply. Sure. So at the last meeting, we were talking about the nicotine and tar yields in packaging. A member raised a question about when that WHO framework came out, so that's set out in our written reply. The World Health Organization has been giving advice on tobacco control. In 2008, measures were rolled out about nicotine and tar yields. Since then, the government has taken different steps to implement the recommendations, such as by increasing the tobacco duty, issuing the health warning, and in the framework of this legislative exercise, we're also implementing the recommendation on nicotine and tar yields. Let's see if members have questions. Mr. Peter Xu, please. Thank you, Chairman. I have a question for Mr. Eddie Lee. The recommendation came out in 2008 saying we didn't have to put on the yields of nicotine and tar yields. What took it 17 years before we implement this recommendation? So we haven't been dragging our feet. Back in 2008, a number of recommendations came out. Recommendations covered the tobacco duty, no smoke areas, pictorial health warnings, and false advertisements. The nicotine and tar yields were part of the recommendations. So we have launched different measures to control tobacco consumption. Those measures came out in the recent years, and we're taking the opportunity of the 10 measures on this occasion to implement the recommendation about tar and nicotine use. For other tasks, we are indeed catching up on what's needed. So I'm happy with the response about catching up. On this part, any other questions from members? If not, we return to our clause-by-clause scrutiny. So will the administration pick up from page 76 of the marked-up copy? Over to the administration, please. Thank you. So we're back to clause-by-clause scrutiny. We're on page 76. We're now in part 7. This has to do with amending Cap 371. This is about the prohibition on selling of conventional smoking products to minors. Now, during our policy discussion, many members raised questions on the ban on giving conventional smoking products to minors. Members wondered if we can implement this ban sooner. We will actively consider this suggestion for committee stage amendment. We're also considering banning the provision of alternative smoking products to minors. So we will consider bringing forth the commencement date for the ban of these two smoking products, and we will let members know. On the amendment, that's under Part 4A. We will put a new provision under Section 15A, meaning no person can sell any conventional smoking product to any person under the age of 18 years. The definition of conventional smoking product is in line with the existing definition. Now you see a technical amendment, and we're removing references to cigarette, cigarette tobacco, cigar, and pipe tobacco. Now we are on page 78. So we are inserting a new offense. Now let's finish page 78, and then we will come to the question from Mr. Peter Hsu. So we will finish page 78 first. That's section 15C 1A. Subject to subsection 1B, a person who commits an offense under subsection 1 is liable on summary conviction to a fine at level 4, that's $25,000. Subsection 1B has this to say: if anyone commits an offense under subsection 1 for contravening section 15A 1A and the aggravating factor does not apply, then this person is liable on summary conviction to a fine at level 3. So the aggravating factor can make a difference in the fine to be handed down. Now, when you have one or more of the following act, that is, you give more than 19 sticks of cigarettes to a minor, or you give more than 1 stick of cigar, or a stick of cigar more than 25 grams to a minor, or you give to the minor cigarette tobacco or pipe tobacco more than 25 grams, or you're giving the cigarette to the minor for a commercial purpose. You may be giving one or conventional smoking product or more such products to a minor for commercial purposes. Those are aggravating factors. The amount under subsection 1C is also referenced to under section 1D. The Director of Health may amend the amount through a notice to be published in the Gazette. Can we pause here? Mr. Peter Hsu has pressed the button. Over to Mr. Peter Hsu. Thank you. The first question has to do with subsection 1A under section 15A. Now, we normally say we don't sell tobacco to people under the age of 18. We call those products cigarette, cigarette tobacco, cigar, or pipe tobacco. Now we are replacing that reference with the phrase conventional smoking product. Why? Why have this reference instead? Will we cover a broader range of products with conventional smoking product than the existing categories? My other question has to do with section 15C 1CA1. Now I see some offenses, meaning you give things to a minor. When you give more than 19 sticks of cigarettes to a minor, you break the law. So does that mean you give just 1 stick of cigarette to a minor, and that's fine? Is that what the law is saying? Before we come to the response, we will stick to our practice from last time. We'll do 4 minutes for each member. So the clock will start from each member starting from now. So over to the administration. I thank Mr. Peter Hsu for his questions. The first question, conventional smoking product. This is a technical amendment. This phrase is defined under this chapter, that is Cap 371, and this means cigarette, cigarette tobacco, cigar, or pipe tobacco. That definition stays the same. We're simply calling these products as a group conventional smoking products. Now you can see the aggravating factor as giving someone more than 19 sticks of cigarettes. This is an aggravating factor. When you give a minor fewer than 19 sticks of cigarettes, that's still an offense. That is simply stopping short of an aggravating factor. That simply leads to a fixed penalty. So, simply put, you're still committing an offense by giving a minor 1 stick of cigarette or anywhere below 19 sticks. Next, Ms. Doreen Kong, 4 minutes. I have a question about the aggravating factors. I'm looking at 1CA. You give a minor over a certain number of cigarettes, that's an aggravating factor. I see an amount. You go above a certain number, and that becomes an aggravating factor. What's the basis for these aggravating factors? Are these aggravating factors also found in the law elsewhere? So how did you arrive at the 19 sticks of cigarettes? We have to draw a line somewhere. As I said, it's never right to give cigarettes to a minor, no matter what the amount is. But once you go above a certain number, we have to draw a line somewhere, and that should be an aggravating factor. One packet comes with 20 cigarette sticks, and that's how we arrived at more than 19 sticks. Mr. Rincon, my second question is, do we have such aggravating factors in the laws of other places? So do we have other places' laws as reference? We don't see any so far. We want to draw a line under this offense. We want to add aggravating factors. Without aggravating factors, we have fixed penalty for the culprits. We have a penalty level that comes with a deterrent effect, but we also have to strike a balance. We want to avoid excessive legal procedures involved. I raised the question for a reason. In Hong Kong's laws, normally a judge considers the fact of a case in deciding on the level of the penalty. And when we write aggravating factors into our law, we should explain how we arrived at the basis for the aggravating factors, because judges follow what's written in the law. That's why I explained, and that's why I asked my question. I respect the drafting as it is now, but I think this looks pedantic to me. Say I'm a bad guy. I just give a minor 17 or 18 sticks of cigarettes, or I can give the cigarettes to a minor in installments. We're being pedantic with the aggravating factors. I get where the government is coming from, but I simply urge caution when we draft provisions on aggravating factors. Deputy Secretary, I think you note Ms. Kong's point. So as we have explained the reasons, so next, Ms. Carmen Khan. As I said during the policy discussion, I supported early implementation of the ban on selling tobacco to minors. The commencement date was supposed to be the 1st of January next year. And the government has said that they would consider our suggestion about early implementation for the committee stage amendment. Smoking among minors is worrying, so we should have earlier implementation of the ban of sale. Now, we're focusing on conventional smoking products here. I think we dealt with the alternative smoking products. Is that the case, Deputy Secretary?
That's correct. We have already dealt with the part on ASP. This division, or this part, is about conventional smoking products. Thank you. Next, Mr. Xiu Kafei. Thank you. I have one follow-up question. If a person who is a retailer or wholesale dealer sell a package of cigarettes to someone, and what happens if they don't know if that person is aged over or below 18? Because someone may look like 30 years old when in fact they are a minor. Is there any way for the dealers to check the age of the buyer? We have set out the relevant arrangements in the following parts. I will ask my colleague to supplement. Thank you. Thank you, Chairman. If I may remind members, the ban on ASP is at page 26. There is a ban on offering ASP to persons aged below 18. We've already scrutinized it. Now going back to page 80, about the ban on offering or selling conventional smoking products to a minor. Currently, no one can sell smoking products to an underage person. There is a statutory defense to the selling of conventional smoking product to an underage person. Under subsection 2, it is the defense to a charge for selling or giving any conventional products to an underage person, as long as the person has inspected the identity card or passport of someone purported to be the holder of the underage person and believed on reasonable grounds that the underage person was not under the age of 18 years, then they have a defense. The relevant person will only have to shoulder an evidential burden. Currently, the seller will have to inspect the identity card of the person of the buyer, and as long as they are under the age of 18, no cigarettes or smoking products should be sold to them. The statutory defense cover not just selling or giving conventional smoking products, but also alternative smoking products. We've already scrutinized it previously. Mr. Shiokafai. Thank you. Well, because the fine was not as high previously, now you're trying to raise the fine and the level of penalty. So what you're saying is that as long as the person has inspected the identity card and believe that the person is aged over 18, then they can sell the smoking products to them. I saw a lot of young people purchasing cigarettes who look like they are in their 20s, and they were sold smoking products from the wholesalers or dealers. But in fact, these people could be aged below 18. As the fine is different now under the bill, I think that you should remind the dealers and the sellers about it. Ms. Doreen Kong. Thank you. Under Cap 371, do we have a definition for identity card? Because some tourists and visitors may not have passports with them, they don't have identity card either. So I wonder what identity card cover here. Deputy Secretary. Thank you. Let me look at the definition. Under Cap 371, interpretations, we have not set out what we do have. Please refer to the English version, proof of identity. Well, identity card is different from proof of identity. By proof of identity, well, for the purpose, it means proof of purpose for the purposes of Part 4A of the Immigration Ordinance, which cover Hong Kong identity card and the passport. So for non-Hong Kong residents and tourists, they can either produce their Hong Kong identity card or the passport when they're asked to produce them. Under this ordinance, I don't see any definition provided for identity card. We only have a definition for proof of identity. Should you not replace the word identity card here with the words proof of identity? Because the sellers can perhaps ask the buyers to produce their proof of residency or residency permits to check their age. I think that perhaps the government should consider substituting identity card with proof of identity. Deputy Secretary. Thank you, Chairman. We will look into it after the meeting. In the original provisions, it is said that the person charged inspected an identity card or passport, so on and so forth. So the same words has been used in both the existing and the new provisions. I have a question myself. Under bracket 2, there are paragraphs A, B, and we also have a subparagraph 3. It says there is sufficient evidence to raise an issue with respect to that matter, and the contrary is not proved by the prosecution beyond reasonable doubt. These do not exist in the existing ordinance. Can the administration explain why you set out these paragraphs in particular? Are you trying to say that as long as the defendant can raise an issue, they have a defense? Deputy Secretary, thank you. As you've said, all you want to do is to clarify that we are only asking for a financial burden to be shouldered by the defendant. The threshold is not high. I will ask the DOJ to explain further. Thank you, Chairman. We think that we should ask the defendant to shoulder just an evidential burden. On top of the defenses for selling or offering or giving conventional smoking products, in Section 10 and 15, we also include these paragraphs to set out very clearly that we only ask for a financial burden to be shouldered by the defendant. Thank you. So as long as the defendant can raise an issue with respect to the matter that they are being charged with, then they have a defense. Ms. Doreen Kong. Thank you, Chairman. I have a hypothetical question for the administration. No one should sell smoking products to an underage person. That's wrong. Now we're raising the fine. Anyone selling the products, an underage person should be charged and they commit an offense. But say, for example, in a convenience store, the boss asks their staff members time and again to try to be strict and check everyone's identity card and passport before they sell smoking products to buyers or customers. But what then? A frontline officer or the salesperson may not check the identity of the buyer because they are fearful of causing trouble, and will that constitute an aggravating factor? Will you charge the boss or will you charge the salesperson selling the product? What if the boss says that they already issued guidelines to their frontline staff? I will ask Dr. Lam to talk about the issue. Thank you. Currently, we prohibit the selling of conventional and all sorts of smoking products to an underage person. We'll try to clarify who is selling the smoking products before we charge anyone. We'll look into the entire process and who should be responsible. who are you going to charge in the scenario that I described? Because under the bill, selling or giving conventional smoking products will be illegal. The boss of a convenience store will not be at the premises all the time. What happens if they have already given their staff guidelines, asking them to check and inspect identity card and passport before selling any conventional smoking product, but the frontline officers do not comply? What happens if the salesperson or the frontline worker did not inspect the identity card of the underage person before selling smoking products to them? Who are you going to charge? Dr. Lam. Thank you. If the employer has already done what they could, they have given sufficient guidelines, and to me, I think that the relevant employer would not be charged. What about the staff member giving the smoking products to an underage person? Well, we have to look at the facts and the circumstances of the case. Dr. Feng? I think that the most important thing we have to look at is who carry out the transactions. I think that it's likely the salesperson that is going to be charged. If there is no further question, would the administration proceed to the next part? Thank you. Now we have completed the scrutiny of Part 7. Now we move on to Part 8, page 81, increasing and introducing fixed penalties for certain smoking-related offenses. We are going to amend the fixed penalty smoking offenses ordinance cap 600. We're going to introduce fixed penalties for several offenses. Giving any conventional smoking product, and in possession of specified alternative smoking product. We're going to introduce fixed penalties to these offenses. Third, illegal smoking act. Say, for example, smoking in a no-smoking area. Currently, we have a fixed penalty of $1,200. Under the bill, we're going to raise the fine from $1,500 to $3,000. We're also going to empower the Director of Health to specify the form of any notice or certificate instead of the Secretary for Health. We just want to make it more convenient for the Director of Health to specify the payment methods and the locations where the offenders make their payment. That's it for my introduction. I will go into the clauses now. We have definitions for specified form, specified circumstance. They will be set out in the schedule, CAF 371. That's the Smoking Public Health Ordinance, CAF 371. The scheduled offenses will be set out in the schedule. 4. Some of the scheduled offense include specified circumstances, some don't. If the scheduled offense do not include aggravating factors, then we can just fine the relevant offenders with fixed penalty. The specified circumstances for reference only.
Next page 82. This is the fixed penalty. A public officer issues a fixed penalty notice. The change here can be found under Section 3. So instead, if a prescribed notice, the notice would be something else. It will be a specified form instead. Next, page 83, it's also a technical change. This is a reference to section 3, subsection 1. Page 84, section 6. When a fixed penalty notice is issued, the person who is issued such a notice may appeal the decision. And that's where section 6 comes in. Again, we're replacing prescribed form with specified form. We now come to section 9. Again, we're replacing the phrase prescribed form with specified form. So section 9 has to do with recovering the fines. The magistrate will issue a notice. The authority in this case will have to submit proof that this person failed to raise a defense or pay the penalty. So any reference to prescribed form will be replaced with specified form. And then we'll come to page 86. Now the Secretary for Health can make regulations on the specified form. Now this will no longer apply. But we will keep something here, and that is the Secretary will be able to make regulation to provide for the better carrying out of the provision of this ordinance. We will have the new section 17A. So instead of the Secretary, the Director of Health may specify in the form of any notice or certificate for the purposes of this ordinance, and that's why we brought up section 6 or 9. This is an administrative arrangement, and there will be no separate regulation for this. Now we will be adding a number of offenses to the schedule. Column 5 will set out the fixed penalty amount. You will see the amount here. The fixed penalty amount will be $3,000, and that's for the offense under section 7, subsection 1 of the existing Cap 371. As you can see under column 4, doing a smoking act in no smoking areas in public transport carriers or while queuing to board public transport carriers or to enter certain places. So if this bill is passed, the fixed penalty will be revised to $3,000. On page 89, this has to do with selling or giving conventional tobacco products to minors. And please note that when we say $3,000 as the fixed penalty, we're talking about the absence of aggravating factors. Page 90 has to do with possession of specified alternative smoking products, again, without aggravating factors, meaning you do not go beyond the limit. The fixed penalty will be $3,000 in the absence of aggravating factors. So can we pause here? We have gone through quite a number of pages. Let's see if members have questions. So the Director of Health will be able to specify the form, and there will be changes to the schedule. So that's what we can see from pages 88 and 90. The fixed penalty will be $3,000 instead. Let's see if members have questions on the provisions we just covered. Ms. Doreen Kong. A question on page 89. Column 4. Giving of any conventional smoking product to a person under the age of 18 years for more than a specified quantity and other than for commercial purposes. So it's okay to give cigarettes to a minor for a commercial purpose. I know I have to refer to section 15C. Can we be clearer on what we mean here by other than for commercial purposes? Deputy Secretary. As Ms. Kong said herself, we have to refer back to section 15C. And that section sets out aggravating factors. And under column 4 of Cap 600, it says, and other than for commercial purposes. Section 15C1CB, it's an aggravating factor to give cigarettes to a minor for commercial purposes. It doesn't matter whether it's a single stick or more than a stick, as long as you're giving conventional smoking products to a minor for commercial purposes, that is an aggravating factor. So you cannot give conventional smoking products to a minor for commercial purposes. If there is a commercial purpose, then that matter will not be covered by a fixed penalty. Instead, another penalty will apply. The 3,000 penalty applies only when you do not go beyond the amount and you're not giving the cigarette for commercial purposes. So say it's an exchange between friends, no money changes hand, and the handing of cigarettes stays within the limit. That's when the $3,000 fine applies. Is that the case? Even if a friend gives you cigarettes and you're a minor, your friend is breaking the law. So it's simply giving of cigarettes between peers, no commercial purpose, that's still an offense. I just find the phrasing strange. I get it. Not everything involves changing hands of money. So have we defined what commercial purposes means? This phrase just got me thinking. Do we have any definition for the phrase commercial purposes? My colleague from the Department of Justice will take the question. DOJ, please. This is about giving smoking products to minors. It's an offense to sell cigarettes to minors. The policy intent here is to be broader in its scope. And that means we can interpret commercial purposes in the ordinary sense, meaning something involves commercial activities, it involves profit. We want to have a broader scope to cover commercial purposes. Ms. Doreen Kong. It's just a thought. The definition of commercial purposes matters because the difference is between a $3,000 fixed penalty and suing someone in a court of law. And you don't have a definition for commercial purposes. So can the DOJ advise the government on this? This is a key distinction. We may disagree over what counts as commercial purposes, because I would be better off with a $3,000 fixed penalty. So can I invite the government to give thought to this point? DOJ. Under Section 15A2, there is a provision on advertisement and promotion. We insert that provision because we want to be watertight in our provisions. You promote smoking products to a minor, you may already be caught under the existing offenses or under the new offenses. The penalties are broadly on a par. So promoting or advertising tobacco products are already covered under Section 15. So when we do get a case, we'll have to look at the fact. So when an accused manages to explain they're not giving or selling the tobacco for commercial purposes, we then look at the facts. You give someone a cigarette because you want them to smoke it, and that's already falling within our framework. We do note Ms. Kong's comment. We will consider the matter from a policy perspective and see what we can do about the drafting. The administration, please. Please continue. I believe we're on page 90. Page 91. So we are trying to put a prescribed form here. The existing CAP 60 contains a number of forms here. In the future, the Director of Health will be prescribing the form instead. So we can remove the entire regulation. We are removing the forms up to page 114. Afterwards, the Director of Health will issue the prescribed forms. Those forms will set out when and how people can pay the fines. Can I just clarify this point? So we remove the existing regulation. There will be a new specified form in the future. So we won't see the specified form here yet. What you can see here is the existing form. In the future, we will have to wait till the new offense to take effect. Say the ban on giving conventional smoking products to minors. Some members argued for earlier implementation of that ban. We will look into that idea. So it is possible that on the date of the Gazette of the past bill, on that day the Director of Health may specify a form. So let's return to page 87. The Director of Health may specify the form. So Section 16 on page 86, the Secretary of Health may, by regulation, provide for a form, but instead now we will empower the Director of Health to specify the form, so that won't be subsidiary legislation. The benefit of this approach is that the Director can add new ways of payment in light of the evolving needs, instead of making administrative changes through subsidiary legislation. Mr. Rincon. So we are giving more powers to the Secretary. The Director, in specifying the forms, will not be subject to electrical scrutiny. When will those forms be ready? Do we have a timeline? Any indicative timeline will do. Deputy Secretary. The format of the fixed penalty notice will be more administrative in nature. Other departments using FPNs do not set out the notices through subsidiary legislation. Some penalties, some offenses will take effect earlier, such as the ban on selling cigarettes to minors. So we will let members and the public know ahead of time. That's more on the administrative side of things. So we will include electronic payment as options for people to settle their penalty notices. So those will be the administrative arrangements.
Ms. Kong, I remember that for, say, road traffic amendment bill or relevant subsidiary legislations, we actually scrutinized the relevant forms in the subcommittees or bills committee. I'd just like to know when we're going to have these forms. What forms are purely administrative in nature? What can be passed via negative vetting? And what forms can be specified by the director or secretary without going through the electrical? I think that the administration have to explain more. I think that Ms. Kong's suggestions and comments are very clear. If you have the forms ready, please send them to the members. I think that the most important thing is that the notices and the forms should be easy to understand. So please look into the matter after the meeting. Thank you. We will publish the forms and the notices. The format will not be that different from the existing ones, but there will be minor adjustments to the details. Thank you. With the administration, please proceed to the next division. Thank you. Now we come to page 115. We're amending CAP 371 subsidiary legislation B. As mentioned, fixed penalty for some specified offenses will be raised from $1,500 to $3,000. Currently, as you can see on page 117, this is the design on the smoking packet. It says there is a smoking offense fixed penalty of $1,500, and now we will update the fine level to, as you can see on the right, smoking offense fixed penalty 3,000 Hong Kong dollars. Now going back to page 115, a new section 10. This is a transitional provision. We provide for a requirement on the health warning on the packet. For the package that is printed on or affixed to a retail container before the 1st of January 2026, then the existing health warnings will apply. However, for those printed during a period 6 months beginning on the 1st of January 2026, then you have to apply the new health warning. So there will be a 6-month transitional period. This is for the sector to adapt to the new arrangement. Mr. Xu Kafai. Now, manufacturers have to print health warnings on cigarette packets. The government is amending one of the versions because in that version there is a fixed penalty notice or fixed penalty level printed on it. It says in the section that during a period of 6 months beginning on the 1st of January 2026, we're just 6 months away from the 1st of January 2026. I wonder if the trade has enough time to amend the design. Previously, when you update your health warnings, how much time did you allow the manufacturers to transition to the new design? I will ask Dr. Lam from the Department of Health to answer the question, because this is not the first time we changed the design of a cigarette packet. Dr. Lam, please. We have made reference to the 2017 amendment to the health warnings. That is the size from 50% to 85%. We allowed the trade 6 months transitional period. All the 12 versions of the design have to amend it. Now we are just amending one of the design. So we think that this 6-month transitional period is enough. Mr. Xu. Thank you. The trade hope that the transitional period will last 1 year because they are worried if the old version with $1,500 printed can be sold in time. In the future, we're going to adopt a plain packaging design. So all the cigarette packets will come with the same design. The government said that starting from Q2 of 2027, the manufacturers have to adopt the new design, the plain packaging. So starting from 1st of January 2026, the manufacturers have to print a new design, and then starting from Q2 to 2027, they will have to adopt a plain packaging design. So why don't you just allow them to continue to use the existing design and change all of the packets starting from Q2 2027? Who will take the question? Deputy Secretary. Thank you. We don't want any packets showing the fixed penalty of $1,500 on the market for too long, because that could be misleading to the general members of the public. That's why we want to be more consistent, as the fixed penalty of some offenses have been raised from $1,500 to $3,000. We think that it's appropriate for us to amend the design. But as we mentioned, we allow for a 6-month transitional period for the trade, and that's enough according to our experience. Previously, we asked the manufacturers to amend all the versions of the design. Now, we're asking the manufacturer to amend only one of the 12 designs. So we don't think that too many packets will be affected, and I think that the trade will be able to cope with the change. Mr. Xu, in 2027, the manufacturers are asked to adopt the plain packaging design, and starting from June 2026, the manufacturers have to use the new version A. And then, starting from mid-2027, the manufacturers have to adopt the plain packaging design. I know that in version A, the fixed penalty is printed. That's why you need them to update the level. Why don't you just ask the manufacturers not to use the version with the fixed penalty printed? I'm not sure if the trade will be able to update the design in time. I think that you should allow the trade enough time to clear their stock. Deputy Secretary, that's a comment. We are going to allow for a transitional period when we go for the plain packaging. Thank you, Mr. Tang Fei. Thank you, Chairman. Under Sublash B, Smoking Public Health Prescribed Information Order, what does information cover? Are we covering just the Chinese and English text? Because on the design, we see a $1,500 banknote in both the existing and the new version. Because if you just look at the image, it could be misleading, because the two banknotes together amount to only 1,500. I wonder if the information cover also the image, because if it also covers the image, then it actually will increase the cost of the manufacturers, because they will have to change the image as well. If they're just changing the text from $1,500 to $3,000, then that may be easy. But if you ask them to also change the image, it could be costly. Deputy Secretary. As you can see on page 120, 122, 121, you can see that we are just amending the text from $1,500 to $3,000. I think that Mr. Xu's question is very clear because in the image we see two banknotes, one $1,000 banknote and one $500 banknote. But after the fixed penalty is changed to $3,000, then the image may not make sense. If the information only applied to the text, then it's very clear. So, Deputy Secretary, can you clarify if the manufacturers will only have to change the words? Yes. I have a question myself, writing on Mr. Xiu Ka-fai's question. Can the Deputy Secretary further explain about the plain packaging design? We may come to it later on, but I hope that the Deputy Secretary will tell us if the plain packaging will replace the health warnings altogether. So in the future, we will not see these images anymore in the future. Please explain. Thank you. Let me talk about the plain packaging design. In 2027 and mid-2027, we will enforce the plain packaging design across the territory. But as mentioned, we have to pass another piece of subsidiary legislation before that, and we will include the information that has to be printed on the plain packaging, including the health warning design to be included. And the design may be specified, and we may come up with new versions that are different from the current ones. In mid-2027, we will implement the new plain packaging design. Before that, we have to pass a subsidiary legislation, and then we have to provide for a transitional arrangement. So by the end of 2026, we will be publishing the plain packaging requirement, and in mid-2026, we will implement the relevant requirement in full. We're going to allow for a sufficient transitional period so that manufacturers can change the design of their cigarette packets. So the manufacturers have to revise their design 2 times before 2027. If there's no further questions with the administration, please proceed. I think that we have covered all the health warnings design. Thank you. On page 117, that's the package of cigarettes or retail container of conventional smoking products, cylindrical drum shape, 1 cigar. The change is all the same. We are amending the text from $1,500 to $3,000, regardless of the container. Thank you. We completed this part. Let's move on to page 123, part 9. Amendments to Smoking Public Health Ordinance Cap 371 to prohibit sale of conventional smoking products containing specified additives, etc., and to introduce certificate regime for conventional smoking products. Under Section 2, Interpretation, we're going to add the definition for certificate of compliance. We're also going to introduce Section 18, bracket 1, bracket CA, that will be on page 132. We're going to empower the Secretary to make regulations and orders, providing for the issue of certificates by the Director of Health for enabling the distribution of conventional smoking products in compliance with Section 10 AAF. I will explain further in detail later on, but to put it simply, the Director of Health can make for the regulations that the distributors will have to comply with. They can cancel some of the certificates and provide for the duty of suppliers to withdraw conventional smoking products in the event of the suspension or cancellation of the certificate. These are not under the principal ordinance, and it will take effect on a later date. Members suggest that we should advance the implementation date for when the Secretary for Health will be empowered to make regulations, and we will see if we will also advance the implementation date for this provision.
Next page, page 124. This is a technical change. So we will put a few divisions under Part 3, Division 1, General Prohibitions. Next page, page 125, a new division, that's Division 2, Prohibitions relating to specified additives. So, new prohibitions. Under this division, there will be two new definitions. One, flavoring. Flavoring means a substance or mixture of substances, no matter in what form and whether natural or synthetic, that is capable of imparting a taste or aroma to the smoke generated from a conventional smoking product, or modifying or enhancing the taste or aroma of such smoke. That's flavoring. So a flavoring has to impart a taste or modify a taste. Can we pause here? See two members wish to speak. Mr. Peter Shiu. Thank you, Chairman. Page 123, Certificate of Compliance. In respect of the product, in relation to a conventional smoking product, conventional smoking products cover cigarettes and cigars. So cigars are included here, correct? Deputy Secretary, are cigars included under conventional smoking products here? That covers the various kinds of conventional smoking products. The definition stays the same. The certificate of compliance will set out the scope of application. Now, on page 125, 10AA, Division 2, interpretation of Division 2 of Part 3, flavoring. We're trying to ban flavorings. Imparting a taste or aroma to the smoke generated from a conventional smoking product, or modifying or enhancing the taste or aroma of such smoke. We have already defined flavoring. Why define specified additive? We have already banned flavorings. Why add the interpretation for specified additive? So let's wait till the administration walk us through that phrase, specified additive. Thank you. Now we're talking about two different concepts. There will be a schedule for specified additives. That's part 1 of Schedule 10. We will spell out what those additives are. Those are some substances to be set out in the schedule. And then there are also some exclusions, meaning a specified additive does not include a substance set out in Part 2 of that schedule. There's a reason. We will come to that on the next page. Section 10AAB, prohibition on sale of conventional smoking products containing specified additives. Now, so how do we tell that it's a conventional smoking product with specified additives instead of simply flavorings? Now, under flavorings, we do not specify the substances. We're simply talking about something that imparts a taste or aroma. But when it comes to specified additives, we are specific about the substances. We're banning those substances. So we know what those substances are. There will be a schedule to set out what the substances that manufacturers cannot include in their product. That's why we have a separate definition for specified additive, Mr. Peter Xu. All good. Mr. Michael Tin. A key figure just passed away. A friend of mine had a meal with this gentleman who passed away. My friend was shocked because my friend grew up in a tobacco family. And this person had lung cancer. After the major disease, this person quit smoking and then teamed up with the Secretary for Health. They made a video on tobacco control. That video had a huge impact on us. The government has been trying to promote a smoke-free city. But we're not banning menthol-flavored tobacco. I don't see the reasoning behind it. I ask, why not ban menthol-flavored cigarettes? At the same time, the Deputy Secretary said they consulted the community, but then there were divergent views. Of course, there were divergent views. There are bound to be divergent views whenever you try to ban tobacco. So now we're trying to go for the middle course. But now you're taking a half measure. You will have more trouble down the road. You kick the can down the road by a few years, more opposition is bound to happen. I'm sure the smoking prevalence will go back up. It will surge instead. More people will get lung cancer. Many lives will be lost because of this. I can say this with confidence. If you do not ban menthol-flavored tobacco along with non-menthol tobacco, I will not support the bill. You still have time. In 2023, the smoking prevalence was 9.1%. Our target is that we reduce that further to 7.8% in 5 months' time by the end of this year. So my question for you is, by the end of this year, are we confident that we can bring the smoking prevalence down to 7.8% instead? So we have dealt with policy questions. But since Mr. Tin has brought up the point about menthol-flavored cigarette, maybe can we get the Deputy Secretary to respond to that point? So we can stick to the clause-by-clause scrutiny, and we can also have Mr. Tin's question answered. Thank you. We discussed this point with Mr. Michael Tin. Our plan was to ban all cigarettes with flavorings. If we can ban everything, including menthol-flavored cigarettes, that is in line with our original plan. But then we launched our 10 proposals. We consulted stakeholders on the 10 proposals. We got feedback that we should hold off on banning the menthol-flavored cigarettes. Instead, we should move on to ban the non-menthol-flavored cigarettes first. So we considered different factors, including the views from stakeholders, and then we arrived at this phased approach. But we are not giving up on the ban on menthol-flavored cigarettes. We will come to that. But we start with non-menthol-flavored cigarettes. Depending on how that works, we will come to the menthol-flavored cigarettes. a phased approach will get greater support. But of course, in terms of tobacco control, it's better to ban everything in one go. Now, I will let Mr. Tin ask his question, and then we will come to Mr. Porter. Mr. Michael Tin, please. The hesitancy to ban menthol cigarettes is that most people consuming cigarettes with flavorings consume menthol cigarettes because you are hesitating to ban the cigarettes that most people consume. You are supposed to deal with the most common kind of flavorings. If you can get to menthol cigarettes, you can make a difference. Look me in the eye. Are you confident that in a few years' time, you can get to the target of 7.8%, and then I will know how to vote? I think Mr. Tin has made himself clear. Maybe a brief reply would do. I thank Mr. Tin. I can see he's dedicated to tobacco control. He supports our work. Now, the target of 7.8%. We set 7.8% as our goal in 2025. That's based on a recommendation from the World Health Organization. So that's down 30% from the previous target. So for us, we should reach 7.8% for our smoking prevalence by 2025. That's in line with the recommendation from the WHO to all its members. That target was set before COVID. The WHO has also issued commentaries. Targets for tobacco control, obesity, and non-communicable diseases were laid down. But the WHO acknowledged that COVID got in the way. The WHO is reviewing its own targets in different aspects. It will be challenging to meet the 7.8% target this year, but that's not to say we should give up. As I said, tobacco control requires sustained effort. We thank members for the support for our 10 measures. Getting this bill passed will go a long way to help us meet our target. My question went unanswered. If we leave out menthol cigarettes, are we confident that the smoking prevalence will not go back up? Now, we are at the clause-by-clause scrutiny. We should be sticking to Section 10AA. I note the question from Mr. Michael Tin. Maybe a brief reply would do. Other members are waiting to speak on Section 10AA. So a brief reply. So is the Deputy Secretary confident that we can keep the smoking prevalence at this level without going back up? We continue with our tobacco control measures. Flavored cigarettes are a priority. We will also need education, publicity, and efforts to guard against secondhand smoke and also stiffer penalties. All those measures come as a package. We are confident that all those measures can help us lower the smoking prevalence. Next, Mr. Porter. A question for the Deputy Secretary, and that's conventional smoking product. Do we have a definition? Conventional smoking product. Do we have a definition for that phrase? There is a definition under Cap 371. The Principal Assistant Secretary can tell us more. Thank you. Under Cap 371, the existing Cap 371, under interpretation, conventional smoking products cover 4 kinds of products, and they are cigarette pipes. So apart from the more generic definition here, the more descriptive definition, do we have any more scientific definition, more specific as to the scientific substances? So anything more scientific, more specific than just cigarette tobacco, cigar, or pipe tobaccos? different products may have different levels of substances. So what standard are we going by, Deputy Secretary?
講嘅嗰四
Apart from the 4 products that I mentioned, there's definitions set out for each type. They describe the nature and the materials of the cigarettes. Say, for example, cigarette means tobacco rolled up in paper or any other material except tobacco. For cigar, it means tobacco rolled up in tobacco in such a form as to be capable of immediate use of smoking but does not include any alternative smoking product. As for pipe tobacco, it means tobacco packaged as being suitable for smoking in a pipe but does not include any alternative smoking product. So this describes how the tobacco is being smoked or being rolled. Thank you. So you do describe the product physically, but there is no definition chemically for these products. Because we do have such standards for food. Because the physical forms of the products can change in times. Deputy Secretary, I will ask Dr. Fong to answer the question. Thank you. We call these 4 products conventional smoking products because they are flammable. These are tobacco products that can be burnt in order to be consumed. Because for new types or alternative smoking products, they are not consumed after they're being burnt. Thank you. Under 10AA, flavoring means a substance or mixture of substances that is capable of imparting a taste or aroma to the smoke generated from a conventional smoking product. How come you describe conventional smoking products by defining their physical forms, but define flavorings in terms of their taste or aroma? Dr. Fong. For non-flavored products, they are conventional smoking product. So for smoking products without flavorings, they are conventional smoking products. They are ones with the original flavor. But what does it mean by original flavor? How do you test if flavorings is added to, say, a pipe tobacco? Who is going to take the question? Deputy Secretary. Thank you. Let me try to answer the question. Under the bill, well, members talking about scientific way of defining things, we're doing exactly that. That's why we use this term specified additive. Here, in Schedule 10, we clearly set out the list of additives and the substance. We have used a very scientific way to define specified additive. We set out what kind of chemicals or substances could not or should not be added to conventional smoking products. We set out the list of substances in the schedule. Chairman, I have a follow-up question. Let's look at Part 1 of Schedule 10, 2ABC. Take cigarettes as an example. Have you tested the components of each cigarettes, of each brand? Because some cigarettes may contain the substances as set out in the schedule. Because if some conventional smoking products contain the substance in the schedule, say for example amino acids and caffeine, then they will be banned. Because there could be 0.001% of conventional smoking products that contain these substances in the schedule. In effect, these conventional smoking products will be banned altogether. Deputy Secretary, thank you. Let me say a few words first, and then I will ask Dr. Feng to supplement. We target flavored cigarettes under the bill, and we don't want to affect conventional smoking products by amending the ordinance. That's not our legislative intent. That's why when we set out the schedule, we include excluded substances. On page 136, these are the preservatives and wax and glue adhesives that have to be included in the manufacturing process of cigarettes. Dr. Feng. The chemical substance in the cigarettes and the smoke and the materials involved in the manufacturing of cigarettes are already set out in scientific papers. Because conventional smoking products are not new products, they have been here for almost 100 years. So we already are fully aware of what chemicals and substances are there in the conventional smoking products. In the Europe, the US, and the Canada, regarding the component, the adhesive used in the manufacturing of the cigarettes, they require the manufacturer to declare all of them when they try to manufacture the products. In Schedule 10, we're talking about additives. So all sorts of additives are set out in the schedule, regardless of whether they are present naturally or not. Additives mean something you add to the cigarettes deliberately to create flavorings. Sometimes in the process of manufacturing, a minimal level of flavorings may be created in a cigarette. When we see if there is any flavorings added to the cigarettes deliberately, we will test the level of it in a cigarette. If it's low enough, then we may consider them conventional smoking products. So we will determine if the flavorings contained in the conventional smoking products is added deliberately or not. We will test out the levels. You don't have a catalog of conventional smoking products. Dr. Feng said that they refer to the practice of Canada. But do we have the same requirements in Hong Kong? Hong Kong is a lawful society. If we are going to hold the manufacturers liable for adding flavorings, we have to be fair. Dr. Feng said that they will look into the levels of flavorings in the conventional smoking products. But if I add, say, 0.001 gram of flavorings, will I be held liable? That's very fake. If what you mean by adding additive is X plus N, then what does X mean and what does N mean? We don't have a catalog of, say, conventional smoking products in order for us to be sure what it means by adding additive. What are the chemical components to our conventional smoking products? You said that there are hundreds of smoking products available on the market. How can we prosecute anyone? If we treat smoking products as dangerous drugs, then we have to be very careful because we are charging manufacturers for adding additives. I'd just like to know the components to the smoking products. I'm talking about chemical components. You have to tell me what X means before you can charge anyone for adding additives to the X. That is the cigarettes, conventional smoking product. Because in the conventional smoking products that are available on the market, they could contain the substances in the schedule. So what constitute smoking products with additives? Deputy Secretary, any response? Thank you. We have been scientific. By additives, we mean substance added to conventional smoking products. These additives are not commonly seen in conventional smoking products. I'm not talking about what's commonly seen. A, B, C, D conventional smoking products could vary in terms of their chemical makeup. I hope that you will be more cautious when you draft your bill. What does it mean by conventional? Deputy Secretary, I fully understand your question. Before we set out the substance, we have already made reference to the practices in other countries. We did not create the list of specified additives ourselves out of the blue. As we all know, a vast majority of cigarettes available on the market come from other countries. As long as they meet the ban of flavored cigarettes in other countries, they should meet the relevant requirements also in Hong Kong. We don't want to affect conventional smoking products and their manufacturers when we regulate and ban flavored cigarettes. If the products meet the requirements in other countries, then if we import these products from those countries, they should meet also our requirements. We're going to provide for exemption and excluded substance that will inevitably exist or arise from the manufacturing process. As Dr. Feng said, we are well aware of what chemicals there are in the conventional smoking products, and we can definitely tell what are news in the products.
Two other members have also pressed the button. Mr. Rincon, please. I can see why Mr. Te asked his question. I think what I see in Schedule 10 comes from other places. It may be from Canadian laws or Australian laws. So we are modeling our bill on laws elsewhere. And I also see a reference to an international body in terms of the additives. And on that list, from that international body, I can see more than 1,000 substances. We're trying to be broad in our scope, and that's where the ambiguity comes from. And I see some flavorings from the list of the expert committee, not even about tobacco. My impression is that we are going for overkill. So, do other places take a similar approach as we do in terms of trying to go for a catch-all outcome? Now, I also have a question. And this has to do with fruit extract and also vegetable extract. Do we know whether there are fruit or vegetable extracts in the paper people use for conventional smoking product? There are thousands of substances involved in conventional smoking products, and even the smoking paper itself is by no means simple. There may be extract, fruit, vegetable extract in smoking papers. So are we trying to even ban smoking papers? So two questions. Is it Dr. Feng Ying who will take the question? So I want to go over Schedule 10, what it covers, and the rationale behind the list. The additives we propose to ban fall into 6 categories. The first kind has to do with flavorings. On this list, we adopt the additives identified as flavorings by the joint FAO-WHO Expert Committee on Food Additives, and also the Flavor and Extract Manufacturers Association. That will cover additives possibly used as additives. We're trying to cast a wide net, and that's for a reason. Flavorings for tobacco are food additives. Each of the lists here contains 2,000 substances, but there is much overlap. So altogether, you have roughly 2,007 or 2,800 substances. Hundreds of additives may be used in tobacco. Flavorings can come in various combinations. When we go for flavorings, we can cover all the substances that can be used as additives. The second item under Schedule 10. Tobacco makers may claim that they add certain substances so that the tobacco offers health benefits. 2B under Schedule 10. Those substances have to do with stimulants. Tobacco makers may claim that those substances can stimulate or invigorate the user. 2C under Schedule 10, those are additives that facilitate inhalation of nicotine uptake, such as ammonia. And there is also another class of additives that can impart a visible color to the smoke generated. And then from 5 all the way to 20, you have menthol-related additives. Some substances here are uncommon in Hong Kong, but we have considered documents elsewhere, such as Article 9 of the WHO's Framework Convention on Tobacco Control. Now, on rolling paper, when flavorings are used for tobacco, flavorings may be sprinkled into the tobacco itself or the packaging or the rolling paper. And that means a ban on flavorings will mean the tobacco maker cannot put the flavorings into the rolling paper. I think this is a complicated matter, so we will let Mr. Peter Xu ask his question first, and then we can have a consolidated discussion. Top of mind for people is that when we ban fruit flavorings, whether the next step will be a ban on conventional smoking product. Some countries have already banned tobacco with flavorings. So those countries should have such laws in place. So have we considered the laws of those places? So overseas examples. Dr. Feng. Back in 2009, the US banned tobacco with flavorings. Their approach was to ban the common flavorings. The EU takes the same approach. But then the best practice comes from two countries, and in those two countries, the ban is imposed on substances. When you look at the US, which bans common flavorings, there were operational difficulties. And that's what prevents the US from meeting their goals. What do we mean by common flavorings? We have yet to see any court case on what we mean by common flavorings. A common flavoring may be banana, fruit, chocolate. You can name a flavoring after a fruit or a candy, but does that count as a common flavoring? What about the other flavorings? We have yet to see any court ruling. The US has banned common flavorings, and then a few years after the ban, new conceptual flavorings came out. Those flavorings are not called lemon. Those may be called tropical cyclone. Despite the ban on flavorings, new flavorings by other names came up. So the ban on common flavorings does not work. The EU similarly has banned typical flavorings. In the EU, they need to get people to smell those flavorings to tell what chemical substance there were. And then 5 years into the EU's regulatory regime, the EU acknowledged that they did not have the resources to implement their regulatory regime. So that means their approach is both complicated and unworkable. That's why we have yet to see any authority on what typical flavorings are. The EU banned menthol cigarettes. Still, transnational tobacco makers launched products styled as menthol reimagined. So the best way to go for us is to learn from Canada. We go after the additives instead. Canada's regime has been in place for more than 10 years. Their regime works. Mr. Peter Xu. I was just asking a question. My question was simple. Is there a country that has banned tobacco with flavorings? If yes, can we adopt their law? I thank Dr. Fong for telling us the full story. So Canada has banned tobacco with flavorings. So why not just follow Canada's laws? So Dr. Fong, so we are following Canada's approach. Is that what we're saying here? So we're not following everything. Canada has also banned menthol cigarettes. We will come to menthol at the next stage. We will also ban the chemical substances that can create the effect of menthol cigarettes. We will ban those chemical substances as well. So this is where we differ from the Canadian approach. Now, I will let Mr. Peter Xu finish his question, and then can come to Mr. Dennis Leung. So I can ask this question on behalf of other members. So Canada is doing this. We're not replicating everything from Canada's approach. Do we have other places that are also banning flavored cigarettes? Can we just copy those laws? Mr. Dennis Leung is waiting, so I will let Dr. Fong answer the question. So we now follow Canada's approach in naming the substances we're banning. But some EU countries are also specifying certain substances they're banning. They do not specify as many substances as Canada does. Some EU countries also name ammonia as a substance they ban. Mr. Dennis Leung is welcome to ask his question after I do. I want to say that I've done research into additives. Now, I'm from the tobacco industry. I'm representing them. I want to make this point. I want to just raise a question. Has the government checked with the tobacco industry whether this list is workable for them? So we have to stick to rules. I have given Mr. Peter Xu time out of discretion. I can say something that will save further questions. I doubt the government met with the tobacco industry. The proposal is to ban flavored cigarettes. If other countries have banned the flavored cigarettes, why not just copy the laws of those places? But now the government is saying they're not copying everything in Canada's laws, and our government has incorporated new elements. We have also incorporated elements of the laws in Brazil and Australia. And the outcome of this hybrid approach, based on my discussion with the tobacco industry, is this. Now, if this bill is passed and then the next day we ban the sale of flavored cigarettes, instead of just flavored cigarettes prohibited, all kinds of tobacco products will be banned because tobacco makers will not be able to meet the requirements. That's why I insisted on asking the question. All tobacco products will be off the shelf right away, not just fruit-flavored cigarettes. Because the government came up with their own requirements, they thought the tobacco industry could do it, but in reality, the tobacco industry cannot do it. So Mr. Peter Xu has made this point. So I will let Mr. Dennis Leung proceed with this question, and then the Deputy Secretary can give a reply. Mr. Dennis Leung, please.
Thank you, Chairman. I'd like to address Dr. Feng's answer. Tobacco makers have different ways to manufacture tobacco products. We now try to ban flavored cigarettes or fruit-flavored tobacco products so that young people will not pick up smoking or become addicted to it. Many flavorings were created chemically. Will the administration be scientific in testing the level of flavorings in cigarettes? Are they going to analyze the component by using a pellet approach? So as long as the substance is proved to exist in the cigarettes, then the relevant makers will be considered to have committed the offense. And the administration will put them to the court and the judge will make a decision. Am I right? Second question. As Dr. Feng said, the tobacco makers may try to work on the packaging. They may turn the packet of a cigarette into one that is shaped in an apple or an orange so that consumers know that the relevant cigarettes is apple flavored or orange flavored. How will the administration work around this issue? Thank you. Deputy Secretary. We are concerned about the issue raised by Mr. Leung. Under the specified additives arrangements, well, Mr. Xu, you said that the tobacco makers have their worries. They don't want to see the ban on flavored cigarettes. But I believe that the makers know very well what chemicals or substance are contained in their products. They are fully aware of what's in their products. We don't have to worry for them. Our regulation and our framework is based on the list provided for in the Canada's law. For menthol flavorings, Canada has already banned it. In Hong Kong, we have not included that. That's our only difference. I don't think that law-abiding tobacco makers will be prohibited from selling their products in Hong Kong just because of our ban. Any other questions? Well, Dr. Feng, let me take Mr. Leung's question. Since many years ago, the tobacco makers have been adding composite and natural flavorings into the cigarettes. The chemical makeup of the natural and composite flavorings are different. Two members have pressed the button. Mr. Xu Kafai. Thank you, Chairman. Now, in response to the Deputy Secretary's answer, many tobacco importers and exporters are very understanding. They have leveraged on their resources to comply with the laws. They told me that if you're enforcing the list, then when the list is enforced, then all tobacco products will be removed from the shelf because otherwise they would be committing an offense. If you're okay with that, then please go ahead with enforcing the law. We're talking about products that are legally being sold in Hong Kong currently. Even though you don't mean to ban conventional smoking products, because we're not going smoke-free altogether, many of the products will still need to be removed from the shelf because of your list. I asked about the 6-month transitional period, and if it worked for the last amendment to the design. The administration said that in 2017 they changed 12 versions of the design and it worked. In 2017, the relevant legislation was passed in June, and the transitional period then lasted 12 months instead of 6 months. I thought you gave me the correct information, if not for my colleague who reminded me otherwise. So the European Union is not banning flavored cigarettes and fruit-flavored cigarettes altogether. Dr. Feng said that many European countries have banned fruit-flavored cigarettes. But in reality, the tobacco makers were able to circumvent the laws, and flavored cigarettes are still available in the European market. I think that it would be better for you to just replicate the laws, the relevant legislations from Canada and Australia, because their laws work. The existing approach does not, however. In the interest of time, I will be very brief. Just now, Mr. Paul, Chair, asked if you can reach the goal of smoking prevalence of 7.8% in 2025. You said that the WHO asked you to reduce the smoking prevalence by 30%. Let me give you an example. If 20 people run for a marathon all together, some people run very fast, some run very slow, and their time difference could be 1 to 2 hours. If you ask them to speed up by 20 to 30%, it would be easy for the slow runners to speed up by 20 to 30%. But for the fast runners, it would be difficult for them to improve their time by, say, 1 to 2 seconds. Hong Kong is already ahead of other countries or places in terms of smoking prevalence. It's difficult, therefore, for us to lower our smoking prevalence by 30%. We have to be clear about our positioning before we set our goal. I think that's enough. Mr. Shields, repeating what he said, I don't need the administration to respond to it right now. There are 2 members who have pressed the button. Mr. Paul Chair. Thank you. I understand the administration want to do what's best for our city. I'm sure that the officers here are experts on this topic. But as a lawyer, I'm more experienced in litigation and advocacy. For the United States, no case of prosecuting tobacco makers making flavored cigarettes. Do you have any case law in Canada or European Union? I've worked on many dangerous drug cases. I've worked on prosecution, on advocacy. They have to obtain GCC, Government Chemist Certificate. Only when we are fully aware of the substance in the dangerous drug can the court prosecute or convict the relevant defendant without reasonable doubt. If you don't have this government certificate, then it's difficult for the law to convict for the court to convict any tobacco makers of the offense. I wonder if the DOJ is confident in their prosecution work. I think that the Legislative Council has the duty to, regardless of how beneficial the bill is, make sure that the rule of law is upheld in Hong Kong. The US and the European Union cannot enforce the relevant legislation. I'm not sure what's the case with Canada. I cannot accept this approach, and that goes against my own principle. We have to be clear about our laws, the details of the offenses. Dr. Feng just talked about aroma, taste. But in Hong Kong, we're not even there yet. We're talking about just the physical forms of the smoking products. How can we ban them? And as a result of your list, you may be banning conventional smoking products altogether. Even if you may be able to have your bill passed, it would be very difficult for you to enforce it. And the DOJ may be undermined as a result. The administration said that you use the food additive standards of the WHO as your requirements. How can we mix food with cigarettes? I know that you are passionate about this bill, but you have to be able to enforce it effectively. The member asked about enforcement, and I know that Dr. Feng has addressed the issues in detail. Deputy Secretary, I will give you time to address the questions very succinctly. There are two members who have pressed the button. I will extend the meeting until Dr. David Lam and Ms. Carmen Khan has put their question, and then I will conclude the meeting. Deputy Secretary, do you have a very brief reply? Thank you. I understand the member's concern, but I do have to make a clarification. We adopt a science-based approach when we drafted our bill. We have already set out specified additives that is scientifically grounded and is enforceable according to the experience of other countries. As most of our cigarettes come from other countries, they are imported. I don't see why, just because of having the list, all conventional smoking products will have to be removed from the shelf. Because in other countries, when they ban flavored cigarettes, they use the same list. If the members fail to understand 1 to 2 particular substance, Dr. Feng already explained about them and why they're included. I just want to clarify that the list is scientific based, and we base the list on the case law from other countries. We don't just copy from here and there. Thank you.
多謝主席。
Thank you, Chairman. I'm worried based on what I've heard. We're talking about additives. Those additives can be found in cigarettes already on the market. Are those additives inherent to the cigarettes, or were those additives incorporated way earlier without our knowing? This warrants investigation. So the first question is, are those substances inherent to the tobacco product? If they are, and we're banning the substances, we are putting tobacco makers in an impossible position. Of course, you can set a limit on the level of those substances. And then if there are banned substances in the tobacco product, does that mean we should be banning the product already with the additives? Because we're talking about two distinct concepts. Dr. Feng or the Deputy Secretary? Dr. Feng. The WHO recommends a ban on flavored cigarettes. The rationale is that it is becoming more and more common for cigarettes to come in the form of flavored cigarettes. The flavorings make it more likely for people to try smoking those flavored cigarettes. The best example is menthol cigarettes. Once you have the menthol eases pain and gives you a refreshing experience. The harshness from conventional smoking product will be suppressed by the menthol, so people are more likely to smoke such products with menthol. And then the menthol also interacts with nicotine, and that worsens the tobacco addiction. Those additives are indeed incorporated into many tobacco products. That's why the WHO recommends a ban on flavorings. That's to make tobacco products less attractive. Now, to use menthol as an example. Menthol may be found naturally in conventional tobacco, but in very small amounts. Medical literature shows the amount of menthol in conventional tobacco may be less than 1 part per million. But when menthol is present as an additive, the amount will go up maybe 100 times as high as before. The ban on flavored cigarettes is to prevent tobacco makers from adding menthol to the tobacco product so that the products become easier to consume for people. Dr. Feng has explained the rationale behind the proposal, but members are more concerned about the standards involved. We will come to Ms. Carmen Kang. Sorry, I was away for another commitment, so I may be asking questions that have been addressed before. I walked into the room, noticing this lively discussion about specified additives under Section 10AA. First, we have a definition for flavoring, and then we have another definition for specified additive. And if we have considered laws elsewhere, and whether the wording of the provisions will make prosecution difficult. So can the government show us the laws we have considered as our reference? Now, on modifying or enhancing the taste or aroma, so where have we adopted that wording from? Does wording like this lead to ambiguities in enforcement? I would like a written reply to this question. I want to find out more about this. I would like some further details on this. Now, on Part 1 under Schedule 10, menthol may worsen smoking addiction because that makes tobacco easier to consume. So that's a reason for banning menthol at this stage. As another member wondered, why leave menthol as it is at this stage? So in that case, should we make a distinction? Should we do something about what we see on page 134 so that we are clearer that we are not banning menthol at this point? Now, on page 132, we should bring forth the commencement date to empower the Secretary for Health. I wonder if we have covered that. The first question is a suggestion. Many members have commented on that point. As for the second and third questions, thank you. Now for menthol cigarettes, we will come to that in phases. Maybe we can set out items 3 to 21 under a separate division, and that will make the bill work better. So that's for page 132. So we will have that part commence first so that the Secretary for Health can make the subsidiary legislation. And this is the same approach we take to the nicotine. First, we set out the power, and then the official can make the subsidiary legislation. So let's stop here for today. The discussion today focuses on flavorings and specified additives. How do we tell between conventional smoking products without the additives and those with the additives? It's a question of where we draw the line. Dr. Feng has explained the rationale. The questions from members are about where we draw the line. Otherwise, people will have concerns about enforcement. So that's the highlight from today. Mr. Porter. Now, I know the government has more resources. Can we find out more about the prosecution and the case and the precedent from Canada? So we discussed Canada's experience. So can we have more details on the Canadian experience, Mr. Peter Shiu? Dr. David Lam also wondered whether we already have additives in the existing tobacco product. Now I'm looking at the paper. Fruit extract, vegetable extract, under number 2 of Schedule 10. For vegetable extract, from what I know, rolling paper often involves vegetable extract. Now people used to make paper with bamboo. They needed the fiber to make the paper. If you ban the fiber, people would not be able to make the paper. That's why we're saying you have to think things through. If you go ahead with this bill, all tobacco products will have to be off the shelf tomorrow. So let's pause here today, and there being no other business, I adjourn the meeting here. Our next meeting, members, will be on the 8th of July. We will start at 9 a.m. next Tuesday. Thank you.